Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'm here today with several other attorneys at Idaho Employment Lawyers. I'm joined by Doug Plass, Jennifer Walrath, and today marks a very special occasion and a milestone for our podcast because we have our first ever guest with us today, Emily McMaster with MacMaster Law here in Boise, Idaho. Welcome, Emily.
Thank you, Pam.
So Emily and I have known each other probably about 10 years or so, and I am really excited to have her here because she brings a really interesting insight to the employment law arena because of the fact that she represents both employers and employees. So when we were thinking about interesting topics for the podcast, we thought, boy, I bet that if we brought Emily in, she could share some insight with employers that would help them improve their workplace and work towards a better culture and avoiding workplace claims and lawsuits. So a little bit about Emily. She's practiced law for nearly 30 years in California and Idaho. She worked for the AG's office here in Idaho. And right now, she's got her own private firm that she started in 2021. So Emily and I were chatting earlier today, and she was telling me how that has been a pretty exciting part of her career. And we were talking about the nuances of representing both employers and employees. So Emily, tell us a little bit about what made you decide to start your own employment law firm.
So I started out after college in human resources. I worked in HR for several years, and I went to law school to represent employers. And so I started at a firm in kind of that big law firm look in California. And during my time there as an associate of that firm, my mom would every year send me calendars of different unions. And so I couldn't even put the calendar up on my wall because it was somewhere our national unions, I would have calendars of them. And so my mom, I think, had always kind of pushed me to try to think about the employee side. And then I came to Idaho and raised a family and was very lucky to work with employers for several years. And as my family had grown and gone out on their own, and I realized that I had a limited time of practice left in my career, I decided it was time and I really needed to be able to see if I could litigate both sides of the spectrum. And so that was my reason for starting my own firm, was to come out and do whatever the goodness gracious I wanted to do, which I have done. So that is why.
Yeah, congratulations. That's very cool. So since you've been in business now for 4 years, one of the things we want to talk to you about is the trends that you're seeing. We had a podcast recently where we were talking about some of the trends that we're seeing and some that we predict for 2025. I'm guessing that you, like us, have seen some changes in the employment law arena. And we were curious when it comes to the calls you're getting, the cases you're taking on. Are you seeing different issues or new issues or some issues that are picking up in quantity or momentum in 2024, more than what you had in your earlier years of the law firm?
I think the primary issue that I've seen, and it would be for government employers, is I'm seeing a lot of equal protection cases. And in the private space, it's your Title VII, your age discrimination and your disability discrimination cases as far as differing treatment. And so I always look at these things. My undergrad, I think I mentioned, was a sociology major. I look at it on sort of a social spectrum. So I always look at what's happening at the national level politically, what's happening at the state level, what's happening at our local level. I think that comes into our workplaces. And so, for example, where we have had themes of equity, such as diversity and equity on college campuses, and now we're focusing more on equal protection, treating people equally without sort of looking at things as equity. I think that that's going to be impacting our workspaces. I really think that what we see on the national spectrum comes down to the state spectrum, and it's going to come into our workplaces. So that's what I anticipate for 2025.
So maybe help of the people listening, we may have some folks who are just in the private arena. Can you give an example, like what would an equal protection claim look like generally in the government sector?
So I've seen a couple of cases come up recently where religion hit up against gender equity. So in the space where somebody is has a gender identity that doesn't fit with a traditional certain religious beliefs about how people should be, I've seen some interconnections between that, where, for example, an employee who was married to someone else of their same sex was pushed out of their employment for that reason in that particular public position. And the training that was given kind of came up on their communication skills. You're not communicating correctly with the people we need you to communicate with in the style we want you to communicate with. And there was actually at one point a communication book that was given that actually professed a certain type of religious belief. And so that was very interesting to me, that I had a potential plaintiff with who was being discriminated against because of their gender and their identity and who they loved. And they were being taught in an employment setting that if they only followed these religious beliefs, that they would be successful in their job. So that was an example. I think we're going to see more of that.
Yeah, and maybe Doug and Jen want to jump in here. In one of our prior episodes, we were talking a little bit about some of the new law on religious accommodation, and then also some of the conflict between Title VII and some of the new state law that applies to public employers.
I mean, I find this area very interesting. I also agree that I think we can expect to see more disputes coming up where there's tension in the workplace between these interests. I think, like, for example, the EEOC did its updated harassment guidance this year. There's a footnote in there that kind of talks about this, but I would say sort of dances around the issue, says we think it's going to be an issue. Kind of what we've set out in here is our position as to what Title VII requires, but not really weighing in on how the balance is going to get weighed when those interests do conflict. I think it really will be case by case. I'm curious if you have any prediction or thoughts as to how you think some of these will shake out once they actually go to court. I mean, I know you have a vested interest perhaps in the case you were just talking about, but if you have any thoughts about, what you think courts will do with these kinds of cases when they see them.
It's going to be interesting. I kind of think religion is going to win at the moment. And I think that it can be even more complicated too. I had another case where they were coworkers, and somebody had a gender identity where they had a relationship with somebody of their same sex. And there was another coworker who had a very strong religious belief that that was not okay. And they were working side by side. And so it was, as we went through the case, it was apparent that it was as offensive to the person who loves somebody else of their same sex as it was to this other coworker who had a religion who said that is morally wrong. I'm not okay with that. And so, of course, I had my own personal beliefs of where I came down on that. But it was difficult. It was really difficult for the employer.
Yeah, I know. And that we talked a little bit about one of our goals here with ground rules is to provide updated info as some of these issues shake out, because it could be in 2025. We don't know, but it definitely feels like things are teed up and employers need to be paying attention to that, because it feels like it's ripe for conflict, ripe for lawsuits, and somehow these things are going to have to get sorted out by courts.
And I think that even on the employee side, as far as being a lawyer for employees, I will always take the marginalized person's side. I will always fight that side. So, and that may depend on the circumstances. I mean, think about it like during COVID when we had people who felt like if you didn't wear a mask in the workplace, you were putting me at exposure of death versus people who are like, I'm not wearing a mask, I'm not getting a vaccine.
Mm-hmm.
I mean, they're difficult.
Yeah. So that's one thing we wanted to talk to you about a little bit is help us understand, like, what kind of cases do you look for? And I think it's just interesting from a personal perspective too, since you've had a lot of experience and have done a lot of different things. What type of things are interesting cases for you, and what makes you take a case versus turn it away?
Right now for me, and this partly is because of where I'm at in life, that I've had the career where I've worked in human resources and I've counseled employers and I've defended employers and I've had that privilege of working for the state and defending state agencies. And so right now where I'm at, with the years that I have left in practice, it's what can I do to make a mark and what can I do to help people that might not otherwise be helped. And so those cases to me are the ones that are of interest to me, and they may not be the ones that are the most economic, but if I take it on, I'm going to litigate it.
Yeah.
So I think that there are probably plaintiffs' lawyers, maybe some who are listening to this, who will say, oh, gosh, no, I got to look at the case and see if it makes economic sense for my firm to take it on. I probably should think about cases that way, but where I'm at in my career, it's more important to me to do what I believe is the right thing.
Yeah. And to enjoy the stuff you're doing.
Yeah.
It makes more sense. So aside from the religion versus possibly gender identity or sexual orientation conflict, are you seeing other trends in the calls you're getting and the cases that you're taking on? Anything else stand out in your mind?
Yeah, one thing, and again, it goes from that, Pam, it goes from that national to state to local level. I am seeing people in power placing themselves in victim status. And from my background working in for a period of time with corrections and looking at they call it the way someone thinks sometimes when they have been convicted of a crime or and they're spending time. The way that they look at it is, some people do, that I'm the victim, right? So this willingness to make ourselves victims, and even when we're in power, being the victim. And the way I've seen that play out in the workplace is that, for example, localities that have, different kinds of, whether it's councils or boards or other areas of government, and people come into those areas of government and they're new and they're maybe younger or less experienced in that area. But the idea is, I'm going to come in and I'm going to make change. I'm a change agent. And so the employees that have been there for a long time, that's a difficult clash. So, for example, one agency I was at a long time ago had a situation where there was a wage and hour issue, and there was a wage and hour issue, and all of the sort of less senior employees went to the person who was highest in the hierarchy that they could go to, and they're like, this is terrible. I don't want to complain about it, because if I complain about it, I'm going to get retaliated against. So that person who had been around for a long time becomes the self-appointed person who goes and complains about it, right? And I have seen that repeatedly in the last few years, where someone who is more senior in the job and has been around, they will decide to use their self-perceived authority to try to help others, and then they get in trouble for doing that. And they get in trouble because the people they're reporting to above them take offense at that.
Yeah. Now, I don't know if anything jumped out at you guys, Doug and Jennifer. There, a couple of thoughts crossed my mind.
Well, I'm just really interested in this just kind of culture of victimhood that we're living in right now.
Doug and I have teenagers. The thought that crossed my mind was gaslighting.
Exactly. Yeah. I accuse them of that regularly, although only one teenager left, the other one aged out. But you talked about being gravitating toward the marginalized folks. Is that a difficult decision to figure out who's marginalized in a particular situation? I imagine it might be.
Yes, sometimes it is, especially when everybody's claiming victim status, right?
Yeah.
That's what I was just thinking about as well, right? Sometimes it's in the eye of the beholder, which is kind of the victim status topic that you were mentioning. So in any event, those two concepts sort of do come together in my mind a little bit. They're probably related. You were commenting on, multiple people noticing a problem, sort of appointing someone to be the ambassador of the problem, and that person ends up getting in trouble, or maybe not in trouble, but something happens that is maybe not favorable for them. And, there's a connection to some degree to what they were reporting on behalf of everybody else. And I would say that we see that as well sometimes, and that can happen. I'm curious if you have any suggestions as to a better way to handle that internally for an employer. I mean, obviously one suggestion might be don't fire the person if they've raised legitimate concerns, but is there anything else that can be done, maybe to even make the, other people more comfortable reporting, kind of what in your experience might an employer do to help improve the culture in which those employees are working so they feel comfortable coming forward?
Mm-hmm. Yeah, I think that number one, if you say you have an open door, then have an open door. If somebody is speaking out more often, maybe rather than perceiving them immediately as a troublemaker or someone who's going against the curve or against the wave, slowing that down and trying to figure that out. I think age plays into it. If the person who's speaking up is 40 or older in a workplace that's primarily people in their 30s and 40s, maybe just be aware of that and slow down, consult with your counsel. And I think that one of the things when you're saying everybody's claiming victim status would be, I think we talked about this a little bit about when I'm going to litigate something, is it because I believe that I have a great culture at my workplace, or I've done a really good job with my workplace, and so it's really offensive to me that somebody is suing me or bringing this claim against everything we've worked for here. And the response is to buckle down and be the victim. Why are they doing this to me? Why are they suing me? Rather than trying to understand where that person's coming from. For example, if they were the ambassador for several employees, did you even stop to pay attention to that and ask about that?
Yeah, one of the thoughts that had crossed my mind when you were first talking about somebody new coming into power and kind of bulldozing their way through is the generational differences in the workplace and what I think is an uptick on age discrimination claims and how that can all play into what you were just talking about, where younger people in the workforce look to the more senior people who have more years of experience to lead their cause, and then that turns into some type of subsequent claim.
Yeah, and the way I will probably phrase that is I'll probably phrase it as a whistleblower claim if I can, or a retaliation claim under one of the civil rights laws, because I know my age claim is going to be harder to bring or may not have as much appeal, right? So depending on what the facts are.
Yeah, okay, you heard it from Emily. Watch out for retaliation claims.
Yeah.
And whistleblower claims.
Yeah, and don't be worried about discriminating against the older folk. I'm not saying that.
That's not what I said. Yeah, that wasn't where I was headed. But, I mean, we do know that our Idaho Whistleblower Act, or Protection of Public Employees Act, is broad, and it is somewhat easier for an employee to bring a claim like that. It's a broad statute. It covers just about anything from our perspective when we're on the defense side. And we know that sometimes employers aren't thinking about retaliation and how a response to somebody bringing a complaint forward can definitely open the door for that. So those are good reminders for sure.
And you all know, those retaliation claims, those are going to get to trial. Those are going to be the trouble ones. So if you can fit under that, that's one thing we'll look at. And from my point of side, that's is somebody using their voice? Are they speaking up? And so that has appealed to me personally. And we didn't mention, but we probably, for another episode, the other thing that's coming up.
Emily's coming back.
No, not me. You need somebody else. But the whole point of immigration, what's immigration going to look like in 2025? That's the other trend. I'm not ready to talk.
Everyone's thinking about that for sure. And I think nobody knows the answer. Yeah. So I want to go back to one of the things you were just talking about, which is the whole question of if you're an employer and you have an employee bringing a claim or suggesting there's a claim or hiring a lawyer who's brought a demand letter, from your perspective, what should an employer think about when they're deciding, whether or not they should settle or pick the fight? You were alluding to that a minute ago.
Yeah, I think there's a couple of things. I'm a big advocate of making your decision upfront early on about whether this is a case you need to fight or a case you need to get past. And the reason I say that is one of the things I've realized working with employees now is that to them, how destructive these circumstances are to their entire lives and their identities. And so when you get a claim of emotional distress, it really is emotional distress. And I think I was telling you, Pam, when we talked earlier, that it might take a employee who's been let go 3 or 4 times to come and tell me what really happened. It can be so traumatizing to them. And regularly, when I get a call from somebody and they were let go 4 days ago or on Friday and it's now Monday, I will say to them, what you need to do is you need to go take a walk with your dog. You need to go down by the river. You need to walk. You need to go get your unemployment insurance. You need to figure out where your head is at. Like, that's what you need to do. Get a counselor if you need to. I am not that first person. We have time. And when you get that stuff together, then if you feel like you need to see a lawyer, then we can sit and talk. But when we think about how important work is to our identities and who we are, and someone takes that away from you, it's so destructive from their point of view. Whereas I think that the employer, my experience with employers is we're usually looking at it as far as like, we did everything right, so why did this happen? You're attacking me. You were always a problem employee, and we have a great company and we don't have time for this. And it's a matter of liability. It's a matter of money. And if there was a way to make that cross between, that we're all humans. And so what do we have to fight every case, every single case? Or what cases do we say we need to just focus on a resolution? How can we get past this as an employer without destroying this person? And can we move forward? Because if we're going to pay our defense lawyers thousands and thousands of dollars, is there a way to just resolve this, not have that impede our business and move forward? Versus, is this a case that we have to fight because they're embezzling from us or they did something that just absolutely crosses the culture of our company or who we are in the marketplace? Those are the cases you got to fight.
Yeah. And that's from our prior episodes. That's one of the things we talked about as part of the reason we decided to do this podcast is because everybody at this table is a litigator. And we do go to court and we do see just how long it takes for the cases to resolve, how expensive it is for the employer paying the bill, the reputational hit, the morale hit, the uncertainty. Once the case lands in litigation, you've lost control and it's tough to drive an outcome on the time frame that you want to see the outcome. So it does make sense to take a good hard look at how defensible is this case? And did we do everything right? And then I would argue that goes back to our training platform, which is you got to make sure you're doing everything on the front end so that if there is one of those issues that Emily mentioned where you feel like you need to defend on principle, you've done everything right so you can do that.
Yeah, and I would add 2 things to that. One is, on top of that, you need to then make the decision, is this the case that it is right for me to fight because I can't live if I don't fight it? Like that, on the employer side, you almost have to do that because if you delay and hem and haw, in the meantime, the employee is digging in further and further and further. They are emotionally and personally digging in on their position because to them, it's a civil rights case. Even if it's not a civil rights case, that's how they see it. And so really getting to that decision, not just did I do everything right, but is this the hill I want to die on? Is this the fight I want to fight? Like that is it's a substantive decision for the employer to make. And I think it's important because it's going to be like, what would it look like if your grandma saw what happened?
Mm-hmm.
Right?
Yeah. And I think employers, I guess playing the devil's advocate, I think they feel like they're between a rock and a hard place because even when they want to do that, I think there's a concern of what kind of precedent are we setting here? If somebody does something and then we just say, look, easier to write you a check than to actually dispute it, we know that can sometimes lead to other claims. So not always the easiest issue to think through.
And the other thing real quick too is early on in a case, and I think you probably will agree with us on this one, is that there often is a difference of opinion as to how much the issue is worth. And that can be a really hard thing to get, and the clients on all sides to be in a similar enough space, even if an employer would like to resolve something and former employee wants to resolve something, that can just be a practical stumbling block that I think, as much as I love what you're saying and I wish that we could always do that, might just be an impediment that takes a little bit of time to get to where people are more on the same page, unfortunately. What were you going to say?
Well, and I was going to say, you talked about kind of this emotional investment and this kind of emotion that employees feel. Like my experience has been, at least recently, a lot of emotion on the employer side as well. And it's an impediment to settlement. It's an impediment to, making rational decisions, and how you get past that, who knows, but I think you get past it by being clear about what you're doing and, having good policies in place and following them.
Well, I think two things that you've said, and this I would come back if you invited me back in a year, is on mediation and settlement,
Yep.
because, Jen, what you're bringing up right now is really critical, which is the ability to assess damages at the beginning of a lawsuit. I think that is difficult on both sides. And maybe perhaps as an employment bar, if we could focus more on that, like how do you do an early assessment that really makes sense? Or does every plaintiff have to go out and hire an economics expert before they even file, right? And the same for the defense side. That's a really critical issue. And I think, Doug, what you're saying too, like the emotional impact of both sides. Employment cases are different than maybe certain kinds of business disputes or other disputes. And I think that we need to realize that if we're going to talk about early resolutions.
Yep. So I think we have time for maybe one more tip or pointer for employers. And one thing I wanted to ask you is we're always telling our clients how you need to document. And even though Idaho's an at-will state, you need to be able to show that you're doing what you're doing for legitimate reasons. Any thoughts on documentation, performance management, anything like that from your perspective?
So I've got 2 points, one on that and one, if I can finish with this. First of all, on documentation, I'm coming for your text messages.
Okay, you heard that one, right?
And your team's messages or whatever they're called, like all of those, I'm going to, demand that we're taking a look at, and not just between you and the employee, but between you and your colleague or your supervisor. I think all of that's really, it's a new world on that. And then the one thing I just to end with is that when you have litigation that comes up, if you haven't dealt with it before, a lot of times your employment lawyer on the defense side is the person who has to deal with like the bad news of what this is going to look like. And if you have like a corporate lawyer who has helped you build your business and they've helped you, do all kinds of transactions and it's super fun and it's really great, you may not be used to that kind of litigation. It is really important to let your employment lawyer get in there early and help you figure out what's going on so that you don't find out 8 months later what the real facts are. And I think that has to do with, I know, Pam, you've talked about asking the right questions.
Yeah, for sure. We always want to be on the proactive side rather than the reactive side. Okay, Emily, that was amazing. Thanks for joining us. I'm going to give just my thoughts on a couple key takeaways for employers. You guys jump in if anything jumped out at you. We heard Emily say she's coming after your text messages. retaliation claims, whistleblower claims, so important that employers know and understand what can trigger those so you don't end up there. Watching trends in the law on LGBTQ plus issues, religious protection issues, and maybe where those intersect. Anything else jump out at you guys, or did I cover the big ones?
I think those are the big ones, but I have to say, thanks, Emily, for being here. It's always good to have a little perspective and reminder about what the, individual plaintiff is thinking and kind of feeling and going through. And probably to me, the takeaway for an employer is to not discount a claim that is being brought because of prior experience working with that employee or some perception they have of the employee, that it's still important to go look at the legal issues, the facts, what happened, and really dig in and evaluate the case without making assumptions.
Yeah. And I would just say that, something I'm taking away from this is that kind of this dialogue in the bar between plaintiff and defense side is really positive toward coming up with solutions. And I just want to thank you for coming and helping us pursue that.
Well, thanks for having me.
You're welcome. Okay, that's it for today. Thanks for joining us for Ground Rules Employment Law over your coffee break.